So let's say you've been admitted to law school, the academic year has started, and you are now a 1L. Let's say it's the first week of your first semester, and let's say that for the first time you are encountering a case. Maybe you've seen cases in the past in some of your pre-law courses, but those have been summaries at best. But now you're staring down the barrel of a full case book with hundreds of cases in it and a very long reading list. So how do you make any sense of this? What are some things that you should look for when reading a case? That's what I'm going to go over in this video today. I'll give you some tips at the very end, but in the first part of this video, I'm going to give you some guidance as to how to even make sense of a case to begin with. So the first thing I want to talk about is I want to talk about the basic form of a case. Now, let me first just point out that there's a number of different sources for looking at cases. The one that I have in front of me right now is an official reporter, or the official Supreme Court reporter, a PDF that's been extracted from that. Technically, if you want to look at what an actual case says to ensure that there's no typographical errors and to make sure that you're getting the exact citations correct, you want to look at the actual official reporter. Now, you could do this physically. You could go down to a library and you will see huge volumes of these cases that are reported in these reporters. You could look it up manually like that. And in fact, for the longest time, that's actually how lawyers went about their business, was they had to go to a law library and look up the cases themselves. Today, there's a number of different sources for that, and I'm going to show you a couple of these right here. So the one that you will be able to access the official reports from would be a place called Hein Online. When you matriculate into law school, you'll get probably a free access to this. You'll be able to access Hein Online, a very expensive database, by the way. If you tried to pay for this on your own, it would cost you hundreds of dollars. But you get to access it for free as a law student. And the great thing is you can type in the citation of the case, a citation that I'm going to show you in just a little bit, and it will actually pull up the official PDF. You can download it right here. It'll show up right there in whatever browser that you're using, and you can see the official PDF that's been scanned in. It's a great resource. You can also look at some of the other places or the other cases that are in that exact same volume. You can also see links to a website that I'm going to talk about in just a second, where you can get free versions of this so that you can read it online and get a really helpful summary of some of the cases. So this is one source that you might look to. You can also, on Hein Online, you can access legal journals, so law reviews, practitioner reviews. You can also access some statutes, especially congressional statutes from the federal government, as well as administrative rules. The one downside, though, to Hein Online is that the search terms are really hard to get right, so you may not be able to find the exact thing that you're looking for. Your legal research and writing courses will help you kind of look through Hein Online and learn some tips, but it's very limited in terms of the kind of searching that you can do. What you're most likely going to have access to is something called Westlaw, or sometimes you may even have access to something called LexisNexis. Westlaw and LexisNexis are paid databases, and let me get my window here so that you can actually see what's going on. These are paid databases that basically are huge, really easily searchable databases of a ton of information that you would usually have to go to the library to, and which may not even be available on Hein Online. We are talking about millions and millions of cases that you can access all the way back in terms of history. You can also access state cases. So if you're trying to search case law in the state that you're practicing in, or in the jurisdiction that you're trying to look at for a client, you can search those things there. I'm not going to go into how you would go about doing that, because your legal research and writing courses will actually guide you through that process. But just like Hein Online, you can type in the search term and you can find the exact same case that you're looking for. These two cases from the Hein Online and on Westlaw are exactly the same. Now, technically, the Westlaw citation is not the official one, because, of course, things could be wrong. There could be technical blips. So Technically, you want to look at the official reporter, so you want to actually see that PDF to make sure you're not getting any typographical errors wrong. But for all intents and purposes, the Westlaw and the LexisNexis people are very meticulous about what they do. They are always cross-checking their information to make sure it's correct. Westlaw also is really useful because it provides what are called head notes. And these head notes can actually give you content or holdings that can be useful for you when you're actually writing memoranda for clients. So, for example, you can find this line that's contained in the Supreme Court opinion that you're looking at, and that can link to other cases that are similar to it to help you start building precedents that you can cite to. Using these kinds of databases is the kind of thing that's going to make for better representation of your clients. It's going to make you a faster attorney, and it will give you way more resources than you otherwise would. Of course, the downside with Lexis and Westlaw is that they are extraordinarily expensive databases. If you work for a firm, they probably are going to pay for this themselves. You may even, if you're in solo practice, foot the bill for some of this. There's also versions of this that are a little bit cheaper. But the great thing is if you're a student in a law school, you're probably going to have these for free, and you're going to get used to using them basically to learn and how to get used to using citations, finding case law, looking at statutes, things like that. Again, your LRW class will go through all of that stuff for you, so I'm not going to go that here. Now, some free sources, some free places that you can go for this information are a website called Oyez. There is a movement afoot ever since the internet age came to be. There's a movement to try to make case law much more accessible. Historically, it's been very expensive to be a good practicing lawyer, and Westlaw and Lexis have kind of had the market cornered on being able to access these materials. But we're becoming more and more open source, and the ideal eventually is that we're going to have all that information readily available so that you can search this material very quickly. Technically, everything's already free and out there anyway. It's just much harder to find it, and the advantage of these databases is it can pull from a lot of different sources. So Oyez is a really great place to look to. And the great thing about Oyez is it gives you all the core information that you might need for writing your legal briefs, something I'm going to talk about in another video. And it also links to the actual cases. It's really great because it gives you facts of the case, how it got there, what the question is in the case, how it resolved. You can actually see the Supreme Court justice breakdown by vote in terms of seniority, and then also by ideology. So you can see who's in the majority opinion and who is dissenting or concurring. And then it will give you a summary of what the Supreme Court actually decided. Now, these are mostly for Supreme Court cases, for the big ones that are coming from the Supreme Court. There are also potentially federal circuit court opinions from like the appellate courts, something I'm going to talk about a little bit later in this video. Unfortunately, there's not a ton of state law that's here in Oyez, but it's getting better and better, and Oyez has these aspirations to be able to do that. The other nice thing about Oyez is when you click on the actual opinion itself, the citation, it will take you to another source, which is Justia. Justia is also a receptacle of U.S. case law, and here you're going to find a ton of stuff that is free and open access. The search terms, again, are hard to pin down, so it's not as thorough as Westlaw or Lexis. It's a little bit more like accessing Hein Online, but it's free. And you can build more of your cases by looking at Justia, and it's growing all the time. You can also get paid versions of this too if you want to. You can create a profile that can save cases that you can access, and you can build all of these cases for your clients someday. As a law student, these are all wonderful resources for your LRW course, and again, you're accessing the exact same materials. Of course, once again, you want to look at the official reporter to make sure it's getting cited correctly. But for the most part, if you want to use these resources, you can. Now, as a law student, though, chances are you're probably going to interact most often with another source, and that is usually a casebook. And a casebook looks a little something like this. A casebook is a summary of the actual Supreme Court case that you're looking at. A case book is basically the thing you're going to buy that is your textbook for your class. These are very expensive books that are going to have tons of information organized by topic, and it will be a guide through the course of the semester as to what the holdings of certain opinions are, how they fit in the law, and basically it's going to be guiding you through the topic. Here, what I'm looking at is a civil procedure casebook. The civil procedure casebook is organized in such a way that it's topical, so it's going through the various stages of civil procedure and how to think about filing civil cases, all the various rules that are associated with that. And because it's organized topically, then you can look at cases that are similar and you can see the development of the law. Your law professors will use these. In fact, sometimes the law professors have actually written them themselves, and they've curated the cases in such a way that they want to look at specific things. And the nice thing about cases, about case books, is that it gets out all of the fluff in the Supreme Court opinions. Basically, you're just looking at the material that your professor wants to look at. So it's much more summarized. It's cutting out information that you would normally have to sift through to actually get to the meat of what the opinion is. And case books are organized in such a way that it's very easy to read the cases. So it's all right there in front of you. And you'll notice there's certain parts where things have been excised. There's certain things that we're not referencing simply because it might not be important for the actual learning exercise. Now, I'm just looking at a Google Books preview of this. I'm using this open source so that you can see an example of it. But as I say, when you actually get into law school, that's where you're going to do most of your reading. So a lot of the things that I'm going to go over today in this video about looking at cases, it's equally applicable to how you would read things in a case book, but I'm also going to be looking at a much more broader way of thinking about cases than just what's in your case book. But remember, the first step in any law school class is you want to start with that case book and not necessarily just immediately jump to looking for citations. So what's the basic form of a case? How is a case structured? What are the pieces of it? And how do you actually read this thing? So what I've got here is the official report. This is the actual opinion that's taken from the official court reporter, so we know that we're getting it right here. And I'm going to walk you through all the pieces of it so you can spot how it's actually organized. Now, over time, the court reporters have changed some stylistic things. The font has shifted a little bit, the margins have changed somewhat, and the court is more and more trying to save on some paper. So what I'm showing you here is really a kind of relic of history in a lot of ways, but as time has gone on, these basic forms have stayed the same. Even if you go back in history 100 or 150 years ago, the basic format is going to look much like this. So here's some of the things you want to look for. First thing, of course, is you want to look for the title. The title is front and center. It gives you who the appellant and the appellee are. The order of who's there and who is the appellant and the appellee. Usually, it's the first person is the one that's bringing the case to the Supreme Court, and the second person is the one that's being hauled up to the Supreme Court to basically raise a question. Remember, the Supreme Court is looking at things from an appellate perspective. There's no witnesses or trial. There's no evidence that's being taken except in very rare exceptional cases. So for the most part, what the Supreme Court is wrestling with is some question that's been presented. Something happened at trial. Maybe the judge got the law wrong, or at least that's the accusation. Or maybe there was bad evidence, or maybe the jury returned a verdict that was impossible to return. Or maybe there's some things that have changed, or maybe the law is controversial. Maybe we're not entirely sure what the law should be. Maybe it raises constitutional issues. Those are the things that the Supreme Court's going to be looking at. And the head note, or at least the title of it, gives you some window as to who the parties are. Here we know it's a corporation, and then we also know that there's some district judge that has concluded something that probably runs up against the interests of the corporation. You'll also get the citation, and the way to look at the citation is you can look in a couple different places. The first is the citation to the reporter. The first number you're looking at here, that's the volume number, volume 444. That's the actual book in the library that you would go to, number 444. The acronym right here, or the abbreviation, is US. That means it's coming from the US reporter. There's other reporters that are out there. There's the Supreme Court reporter, which is a whole separate number of volumes that have different volume numbers, different pages, etc. But the US reporter is the one you probably want to look at for the Supreme Court cases. If this is a lower court opinion, it's going to come from like the federal district court reporters, or it's going to come from an appellate court reporter, and the abbreviation will change depending on what level you're looking at. We'll talk about that a little bit more when we talk about court hierarchy. The other thing you're going to look for is the page number. This is where the case starts, page 286 of volume 444. And the pages go for 34 pages, so it's going to be 286 up to 34 pages after that. So that's the range of pages that you would look at. The first time you cite this, when you actually look at like the Blue Book citations, is you'll cite this piece so that people know exactly where you would go to find this case. And then after that, you'll give what are called pin cites, that are exact locations in the opinion, the exact page number that you would look for the quotation or the holding that you're actually citing to. The other thing you can look for is the number. This is basically the term and the number that's assigned to that case during that term. So this comes out of the 1978 term, and then it's number 1078. And those numbers are applied by the clerk of the court. It's basically the sequence, the number of cases that are coming in, and it's sequentially ordered in that way. That one's only really useful if you're trying to do specific Supreme Court research. Chances are, if you're trying to write about the case, this is the official citation you want to look to. The other thing you're going to look for is the origin. Where is this case coming from? So here it's certiorari. That means a petition. You're seeking that the Supreme Court take the case. So it's coming from an appeal in some respect. You ask the Supreme Court to take the case, and the Supreme Court has agreed to do so, and it's coming from the Supreme Court of Oklahoma. That's a state Supreme Court. So someone has appealed this decision from the state of Oklahoma. That's really helpful. That gives you an idea as to where it's coming from. It might also say certiorari from maybe the 11th Circuit, which means that it's coming from the 11th Circuit Federal Court of Appeals. And it's really important to remember those distinctions, because sometimes the Supreme Court only takes certain cases from the states, and then all other appellate cases come up through the federal jurisdictions. Also look for the date, when it was argued, so when it was actually brought before the Supreme Court to be considered, and when it was decided. Now you'll notice this is 1979. Why is it 1978? Because chances are that's the year that the certiorari was granted, but then it was the following year that the case was actually argued. That year gives the parties some time to be able to file their briefs, for other parties not associated with the case to file what are called amicus briefs, or friends of the court. And then that year is basically when the case was actually presented to the court in oral argument. But it was decided, and the important decision date is this one, when it was actually rendered, when the Supreme Court delivered their opinion and said this is what the holding is. So this second date is really the one you want to look at, 1980. So the date is crucial because it gives you an idea as to the historical footing that we're looking at, what the period of time actually is, and it will give you an idea as to what the case stands for in terms of its historical purpose. So sometimes you can look at the date and you know who's on the court, you know who might be writing the decision, and it will give you a window into basically what the court might be thinking at that given time. And over time, you'll get used to this. You'll be able to spot certain time periods. What I know, for instance, from this is that Justice Brennan is on the court, a very liberal justice. And I also know that Justice White is on the court, and he may be the one delivering the opinion for this. So all that is stuff that you'll kind of pick up as time goes along. Then the next piece that's going to be reported in this reporter is what's called the syllabus. Now, you know the word syllabus is something that you get when you start a class. It gives you basically the policies in the course. It gives you the reading schedule. The syllabus is something that you've been used to looking at for class materials. And that's similar to what the syllabus is going to look like in the Supreme Court opinion. Syllabus just means a summary. So syllabus in a course is a summary of what the course is going to look like, and a syllabus in a case is a summary that's written up to give you a nice, neat look into what the Supreme Court opinion is. Sometimes opinions, when you stack up all of the various majority opinions, the concurring opinions, and the dissenting opinions, it can go for hundreds of pages, and you will have to shift through all of this language. Supreme Court justices love to talk and they love to write, so sifting through all that information could be tough. The nice thing about a syllabus is it basically gives you a good summary right here at the front end. The only thing about the syllabus, though, is it's not official. This is not written by a justice. No judge is actually writing this material. It's written by the clerk, and the clerk, although very authoritative in the sense that you can potentially trust that person, they're not really the justice, so nothing that's written in the syllabus is actually binding. So you don't want to cite to the syllabus. The syllabus is really just a guidepost for you. So it will give you a summary of the facts to give you an idea as to how we got to this stage in the first place, and then it will give you a summary of how the Supreme Court made the decision. What was their holding, essentially. And the nice thing about this, too, is it can give you an idea as to what the topic of the case is actually about. This one's going to be looking at in-person jurisdiction or personal jurisdiction. That's a civil procedure topic that basically looks into how can the court exercise its authority over the individual that's being sued in the case. That's a topic that you're going to explore in civil procedure. Where does that power come from, and what are some of the rules that are associated with that? So we know that Worldwide Volkswagen is a case that's going to touch on that doctrine. After the syllabus, what you're going to find is you also get a breakdown of the voting. How did the justices make their decision? So who decided what? How did they align up with one another? What is the majority opinion? Who voted in favor of the majority opinion? Who concurred but wanted to write a separate opinion? Who dissented? In other words, who's voting against this? And it gives you a nice window of the breakdown. Over time, as you get associated with certain justices, you kind of figure out who's going to agree with one another, especially if it's a constitutional issue that involves some political considerations. The liberals vote together and the conservatives vote together, but not always. And being able to look at the breakdown of the votes gives you a nice summary of what the case might actually look like. Sometimes you'll see some really important surprises. Sometimes an ardent conservative lines up with the liberals on a particularly interesting topic of constitutional law. The other thing that's helpful right after the syllabus is that you can get some citations to the places in which the dissenting and concurring opinions start. So it will give you a way to kind of jump to the part of the opinion that you really want to look at. Remember, the piece that you really want to look at, the actual official thing that the Supreme Court is saying, comes from the majority opinion. So you want to look at the first part of this opinion before you ever get into the weeds of the dissenting opinions. The only thing that's binding on the parties comes from the majority, and that's based around the majority opinion. Another nice thing that you'll see right after the justice breakdown is you can see the names of some of the lawyers who are representing the petitioners or the appellee. That gives you sometimes a window as to who's doing this. Certain lawyers are sometimes more famous than others. But usually that's not really totally relevant to the opinion, but it's there, something worth looking at. Then after all of that introductory information, that's when the opinion of the court actually starts, and that it will tell you who's writing the opinion. The person who is the majority writer is oftentimes selected by who and how they agree, or how the justices agree with one another. The Chief Justice can sometimes assign a certain judge to write the majority opinion if the Chief Justice is in the majority. But for the most part, the 9 justices are all kind of making their decisions themselves. They're meeting in conference to decide how they're going to decide the case, and then the majority writer gets to kind of choose whether or not they do this. Sometimes it's rotated too. Here, in this case, Justice White is delivering the opinion of the court, and now we are off and running. This is exactly what the Supreme Court thinks about the decision. The first paragraph, especially today, as the Supreme Court has become much more uniform in its format of cases, The first paragraph is usually introductory, and it will give you a kind of brief summary as to where we're going with the opinion. But where you really want to start reading is right here in section number 1. Usually section 1 will lay out the facts of the case. It will give you an idea as to what the issues are, who did what to whom, who got injured. All of those things are sometimes relevant to the actual decision. So that gives you an idea as to how the justices are thinking about the issues, how the facts actually come to be. That's where you're really going to want to look at who did what to whom and how that might help your client if you cite to these cases. Then, by the time you get to section 2 of the opinion, this is when you start to lay out what the rules are. So just like you're writing in an IRAC perspective, something I'm going to talk about in my LRW video, the justices are also doing the same thing too. They're laying out the issues in the first section, the factual issues that are going into the case, and then they're going to start citing the law. What does the current law say about these things? Then once that section is over with, then they're going to start analyzing how the rules fit within the factual analysis. So what is the problem? How are we going to answer the question? That usually begins in about section 3 or so. And then there can be other sections after that, depending on how many issues the court is faced with and how many ways in which the court wants to think about these things. As you go through the majority opinion, you're going to see tons of citations to other decisions. You're going to see them scattered throughout here. And the Supreme Court is usually citing itself for the authoritative precedents, but then there's also some pieces that they might be citing to from like state courts, maybe even international sources, statutes, things like that. And you can look for the citations scattered throughout the decision. There's also going to be, by the time you're done with this, there's going to be a regular analysis of how those precedents fit with the current case. So if they're changing precedent, you'll be able to pick that up, or if they're extending precedent, you can pick that up too. All of that is really useful information. The other thing you're going to see a lot of is footnotes. So once you get down to the conclusion, the court is basically summarizing what's happened, but you'll also see regular citations to the footnotes. Footnotes are things that are helpful in terms of what the court might be thinking on the side. The majority writer might have an idea that's similar to an idea that they're discussing, but they don't want to draw too much attention to it. There might also be citations to particular pieces that are somewhat relevant but shouldn't be cited in line. Then at the very end of the decision, once the conclusion is reached, you will get an order. There will be some kind of decision as to how this affects the parties. So this is not really about the precedent. This is really an order to the lower courts as to what to do with this. So remember, this is an appellate decision. So a trial has taken place, then we've appealed, and now we're up at the Supreme Court. And the Supreme Court, as the most powerful court in the nation, is going to order something to happen. Either they're going to order that the judgment has been affirmed, so whatever happened at trial or whatever happened at the appellate courts, the Supreme Court is accepting that decision through an affirmation. Or they might reverse and simply say, look, we're going to overturn what was decided below. In this case, that's what's happened, is they've overturned the decision. So they've reversed something, and a party now that was once losing is potentially winning from this. And then other times it will be reversed in parts and then affirmed in parts, and it's really important to read the majority opinion to figure out what parts are actually relevant. When you get this as a client, for instance, or when you're representing a client, and if you get an order from the Supreme Court in a case, you're going to have to figure out, well, how does this affect my client? And this last paragraph is a good way to do that. Then, after the majority opinion, you'll start into any concurring and dissenting opinions. Sometimes the justices feel very strongly about their position and they wish that they would have won. So whatever the minority side of the court is doing, they're going to write an opinion that dissents and basically says, I don't agree with what happened in the majority opinion. So you want to look for that. You want to look for what justice is writing that decision. But the key thing is that there's nothing binding about the dissenting opinions. Those are really just good information, and it might signal that maybe the court will change its mind in the future, or maybe that this is a very controversial decision, but there's nothing authoritative about the dissents. It's really just important or helpful information. Now, concurring opinions could be helpful, especially if the concurring justice is so-called the swing vote. If you're looking, for instance, at a case that has Justice O'Connor as the person that's really deciding this, maybe there's 4 justices in favor and 4 justices against, and Justice O'Connor is the one that's concurring in this, maybe her language is really helpful and authoritative. But again, it's the majority opinion of the court that actually tells us what the law is. So all those concurring and dissenting opinions are really just helpful information. So that's the basic format of how a case looks. Those 9 pieces are really helpful in terms of thinking about this. When you look at your actual case book, you may not see all of that information, but you're still going to get the most important pieces like the title, the citation, the date in which it was decided, and the core part of the holding, how it actually fits into the law. So that's a really helpful look into how this is actually broken down, and you can always refer back to this video if you're really confused as to how a current case is being set up. The next thing that I want to look at is just a brief summary of how the courts are organized in terms of hierarchy. Now, for the most part, I'm looking at Supreme Court decisions here. That's the one that I was actually citing to. And in most of your case books, you're going to look at a lot of Supreme Court decisions. There's Supreme Court decisions by both the federal government as well as state courts. So mostly you're looking at very authoritative, high-level, highest court kind of decisions. But you may occasionally look at appellate court decisions, especially if the Supreme Court hasn't yet weighed in on an issue, and you can kind of see how the circuit courts are making these decisions. And you may even look at, especially if you're in a trial advocacy course, you may look at individual trial courts. Hopefully by now in your college career and going into law school, hopefully you already know what I'm about to talk about. But if you don't, here's a quick and dirty version of it. So we have the highest court in the nation is the U.S. Supreme Court. It's the only one that's created by the Constitution, but underneath it are subordinate courts. On the federal side, the next level down are the courts of appeals, or the circuit courts. There are 13 of these, and they are organized geographically. So the circuits are based around states. So for instance, in the Ninth Circuit is made up of California, Oregon, Idaho, Washington. That Ninth Circuit is basically any case that's appealed from district courts in those states would go up to the Ninth Circuit. And there's various offices in the Ninth Circuit. So you don't just have to go to one location in the Ninth Circuit. There are many judges, and those judges will take cases from nearby geographic regions. Then below the circuit courts are the trial courts, also called the district courts. District courts are where the whole thing gets started. This is where you're meeting with a judge and a jury. This is where lawyers are presenting evidence. This is where witnesses are being called and there's a fight. What's happening at the trial court level, especially in federal courts, is you're building a record. So basically you're trying to figure out what happened to whom, and you're building that record based on evidence. And the judge is going to conclude, well, you can bring in that evidence and those facts are relevant, but maybe these other pieces of evidence are not relevant or they're not permitted evidence and therefore it can't be brought in. Then the other thing that's happening at the trial court level is there's some kind of verdict. If it's a criminal case, it's going to be guilt or innocence. And if it's a civil case, it's going to be liability, who owes what to whom. And those two pieces, the facts and the verdict, are what get the whole thing started in terms of appeal. Now, the Court of Appeals, they're just looking at law. They're not really taking evidence. They're not really looking at what witness said what. It's really mostly looking at, did the trial court get anything wrong? And trial courts do get things wrong, sometimes a lot. There could be all sorts of things go wrong, like the lawyers were poorly representing their clients, or there was some level of corruption, or maybe the jury screwed up, or maybe there were pieces of evidence that shouldn't have come in, but they did, and it affected the verdict in some way. Or maybe there's new evidence. Maybe there's an appeal that says, look, we need to bring in this new evidence. Or maybe we just need a whole new trial. All of those things could be potentially relevant. One of the big things the circuits are looking at is whether or not the district court got the law correct. Trial judges are oftentimes very overwhelmed with the facts and the proceeding, and sometimes they may not know 100% what the law is, or maybe the lawyers cite to the wrong stuff and the trial court concludes something that's just not accurate. So the Court of Appeals is kind of supervisory. They're basically looking to see whether or not the trial court judges are getting it correct. And if there's an open question, like maybe the law is not totally clear on an issue, circuit courts will make that decision. Now, sometimes the circuit courts are going to disagree with one another. So one circuit will hold one thing and another circuit will hold another. This happened, for instance, in cases like involving gay marriage. Sometimes circuits were saying it was a constitutional right. Others were saying it wasn't. Sometimes the circuit courts also just get the law wrong. Maybe they just are citing or incorrectly stating something. In those cases, when there's a problem at the circuit court level, that's when the U.S. Supreme Court steps in. That's when they're most likely to grant certiorari and to accept your case. Courts of appeals usually have to hear your case. If you appeal, you have a right to have that appeal, but the Supreme Court doesn't have to hear your case. They can reject a case and they don't have to accept it. Now, on the state side, there's also basically a similar setup. There's the trial courts that are happening in the local jurisdiction, a local county trial court, for instance, or a city trial court. Then there's courts of appeals, similar to the circuit courts. They're doing similar things, but they're looking at state law instead of federal law. Then there's the highest court within the state, and that's usually a state Supreme Court of some kind. And then those appeals sometimes can be taken to the Supreme Court, especially if it involves federal issues or if it involves certain things that are tied to federal law in some way. Sometimes, too, that it can be appealed to a circuit court, depending on what kind of law it is. Now, those are usually the ways in which you get up to the Supreme Court. That's how the Supreme Court manages its docket. There's also these random courts that the Congress has set up. These are federal courts that Congress has decided are unique, and they're basically really important for specific reasons. These include things like the Court of International Trade, military appeals, so anything that's happening at the military level, like in JAG cases, for instance, and then the Court of Claims involving things like tax law, bankruptcy. It can also include like government contracts. Those are proceeding through a different route. Sometimes they come directly up to the Supreme Court through these trial courts. Other times they might go through a circuit, but that's the different ways in which the judiciary is set up. Now, why am I saying all this? Why should you care about this? Because there's a hierarchy of authoritativeness. The Supreme Court is always authoritative. If the Supreme Court says it, that's the law. And you want to look at the most recent statement of it. So look in terms of recent history and then go backwards from there. So whatever the most recent opinion of the Supreme Court is, that's the law on that issue. And then after that, you start looking at the lower courts. So if the Supreme Court hasn't said what the law is on a particular topic, that's when you start looking at the courts of appeals or the U.S. or the Supreme Courts for the various states. Sometimes if it's a state law issue, the Supreme Court may not even be touching that issue, in which case you want to look at the individual Supreme Courts within your states. And then within that, of course, there may be disagreements. You want to look at your jurisdiction. If you're in the Ninth Circuit, for instance, you should be citing Ninth Circuit opinions. You shouldn't necessarily be citing 11th Circuit or 10th Circuit. So look at the place in which you have jurisdiction. If the Ninth Circuit hasn't said anything, then maybe you can cite to other circuits as a way to kind of helpfully convince the Ninth Circuit as to how they might think about something. Same thing is true on the state side. If the state Supreme Court has not really wrestled with the issue, maybe you can cite to other states. You can also cite to the federal government cases to help convince the state. But if the Supreme Court in your state has said something, you need to be citing that state's law. Same thing is true with the appellate courts. If the highest court in the state hasn't said anything, cite the appellate court that's in your jurisdiction. And then if there's just nothing to cite to, you might cite to other trial courts so that a trial court judge can say, well, this is what some of my peers have been doing. And again, you're citing only to jurisdictions. You can also cite to statutes too. Congressional statutes and legislators are oftentimes more authoritative. So if the Congress has decided something, depending on what the issue is, Congress's will is more or superior to the court's will, unless it comes to things like constitutional issues, in which case the Supreme Court reigns supreme oftentimes on those constitutional issues. So hopefully that gives you a nice window into thinking about how these cases should be read and how they should be cited too. The last thing I want to do in this video is I want to give you some tips as to how you might read these cases. These are 3 tips that will help you in law school as well as representing clients. And it's really important to have these in your mind as you start the process. You, as a 1L, are going to get overwhelmed really, really fast. And you may not be able to have time in the day to thoroughly read every opinion that you are assigned. So it's really important to keep these tips in mind because they will help manage the way that you think. The first tip that I have is to do a quick pass of the opinion in terms of thinking for the forest. You're reading for the forest. And to use that analogy of a forest, think of tons of trees. There's tons of information within this opinion, and you're really just trying to get a high-level view. Imagine looking at a forest at 30,000 feet. You're seeing the whole thing. That's the way you should really start looking at an opinion. Basically, you want to get a good sense just from skimming and looking at the syllabus, looking at summaries, reading some of the footnotes. You're getting a top-level view as to, okay, what's this case about? What's the topic? What should I be spotting when I'm actually reading it for detail? And also, how does it fit with all the other cases I'm looking at? If you're using, for instance, a case book, chances are this is happening in sequence. Maybe you're covering a whole section on what a criminal law of murder is defined as, and there's 6 cases you're supposed to read. So you might look and say, okay, how do these pieces fit together? I've already read one case, and now I'm about to read this case, and it seems to be about something different. So how do those two relate to one another? The other thing you might be looking at is time period. So if it's a Supreme Court decision, maybe you've read one that was in the early 20th century, and now you're reading one that's very, very recent. That might signal to you that maybe the law has changed, and it will give you an idea as to how you're progressing through those various ways of thinking about the law. It's also maybe there's specific problems within constitutional law or within the topic that you're looking at, and maybe this case that you're looking at covers that particular detail. So you're looking mostly for summary at this point. My second tip is then once you've considered the summary and looking at the high-level version, start looking at the trees. So you've now zoomed in terms of your ways of thinking about this. Oftentimes when you're reading for cases, the reason why the professor has assigned this case is there's probably one core part of the case that's very, very relevant, and it stands for something. It's a 2 or 3 sentence summary of what the precedent of that decision is and how it has a bearing on the rest of the case. You're never ever going to be able to get every single detail out of a case that you're reading in law school. There just isn't enough time, and you don't have enough mental bandwidth to be able to do that. So the way that you should be thinking about this is how this fits into your outlines. That's a video I'm going to cover in another, or a topic I'm going to cover in another video. But at least in terms of reading, you might think, okay, well, what can I actually do with this decision? How does it fit within all the other decisions I've looked at? And what's the nice core nugget that I'm supposed to be extracting from this? And the more quickly you can get to that point, the more quickly you can get to other opinions that are assigned in your reading. And then my last tip is you want to think like a lawyer. And the reason why I emphasize that is because that's how you do well on law school exams, and that's how you become a good practitioner. Now, what do I mean by thinking like a lawyer? You think, how can I use this? Imagine you're representing a client. The client has come to you with a problem, and the problem involves some kind of law that you're going to have to advise the client about. And you're going to have to present this information to a trial court. You're going to have to use it in convincing the trial court to agree with you. And you're going to have to be prepared to fight against the other side who's got a completely different way of thinking about this. So when you look at that opinion, you should say, how can I use this if I were representing a client? So let's say the client's got a problem. Let's say the client has been charged with murder, and murder is defined in a certain way in your jurisdiction. But let's say the client has got an exception. Let's say it was a self-defense argument. Maybe this case has a good 2 or 3 sentence summary that can tell us what the law is about getting an exception in the case of self-defense. What is self-defense defined as? How do I prove self-defense? What kind of evidence would I need to find? And then how does it actually affect the penalty? Does self-defense mean that I get a judgment of innocence, or does it reduce my sentence in some way? That's what you're gleaning from the case, and that's what you'd be using for a client. So do that as a law student too. How can I use this, and where does it fit in? That's going to give you a lot of good skills when you actually start applying these in law school exams, because law school exams are really asking you to do that very thing. How do these cases fit, and how can they be used in a fact pattern? The nice thing is your legal research and writing courses are going to be teaching you these skills as well. And I'll be talking about legal research and writing in another video. But at least for now, that gives you a good stepping stone into thinking about this. Well, I hope this video was helpful. At least that will give you a start in terms of thinking about and reading cases. If you have questions, of course, you can always email me. Happy reading.